Good afternoon. Welcome to CPMC's webinar. Today we are going to discuss Immigration 101 for Ministry, tools to support those on the journey. It is a practical overview of today's immigration system, including what families and individuals face before, during, and after detention. We'll explore how your ministry can become a source of hope along the migrant journey. My name is Imelda Richard, and I am the Prison Ministry Coordinator for the Archdiocese of Atlanta. I partner with CPMC on many things, and you will see me sometimes on some of the webinars or some of the classes that I help facilitate. So thank you for your time and being here today. We are going to start today's webinar with a prayer. In the name of the Father, and the Son, and the Holy Spirit. Amen. Nuestra Señora, whose heart is full of a mother's love, whose mantle comforts and protects us, gather and hold all who are forced to flee their homes because of violence, poverty, or oppression. Form us as you did your Son, to soften our hearts, to steady our hands, to accompany all of our human family made in the image of God, each reflecting the Creator's goodness. We look to your example as guidance in adopting a posture of presence, becoming vessels of grace, revealing the beloved kingdom where all are one. Amen. In the name of the Father, and the Son, and the Holy Spirit. Today, we have two wonderful presenters. We're going to have first, Zaira. Zaira Solano is the founder of the Solano Immigration Law Firm, a nationally recognized immigration practice focused on fighting deportation and helping immigrants build a better future. She was just recently named one of 5,000 top female founders in 2025 and leads a firm that also funds college scholarships for immigrant Black and Latino students. A proud Dominican American and mother of three, Zaira brings in a powerful voice to conversations about immigrant justice, entrepreneurship, and building a legacy through service. And we are also going to hear from Tonia. Tonia Maglione is an immigration attorney and an immigrant herself, originally from Naples, Italy. In 2019, she earned her LLM in American Law from Wake Forest University School of Law. As a student, Tonia was recognized as a member of the Pro Bono Honor Society and was honored with a prestigious Dean's Award. Following graduation, Tonia worked for over 3 years as an immigration paralegal. Her personal experience navigating the U.S. immigration and naturalization process, culminating in her U.S. citizenship in 2019, deepens her empathy for her clients and inspires her volunteer work. After becoming a licensed attorney, Tonia joined an immigration law firm where she represents clients before the Immigration Court, USCIS, and on detention. Her approach is hands-on, centered, and deeply committed to justice. If you have any questions throughout this webinar, please enter them in the chat, and we will ask them on your behalf later in this presentation. Zaira wasn't able to be with us in person today. She had to be at court, but she recorded her presentation for you. And later we will have Tonia answer your questions, and she will be with us in real time. So thank you for being here, and here we go on this learning experience. Thanks.
Today's objective is to train you on basic immigration procedures and laws that affect incarcerated immigrants. We are going to discuss ICE enforcement, triggers to what happens after people are arrested or they plead to certain crimes or they're found guilty of certain crimes. And then I'm also going to help you identify some very basic defenses that people may qualify for that they can assert against being deported from the United States. So as I was saying a moment ago, The current state of immigration law is the toughest that I've seen in my 14 years of practice, and the toughest that some of my colleagues who've been around longer than me and this country has seen, probably since the early 1900s. The laws haven't actually changed. The laws continue to be the same. The last time that we had immigration reform was back in the last Bush administration. On or around the year 2000, we had an amnesty. And before that, in the 80s and 90s, were when many of the immigration laws were updated. We haven't seen significant change through Congress. What we have seen in this administration, in the previous administration, the one before that, and all the presidents that have been serving for the last 15 years or so, are executive orders. And that is what has been shaping a lot of the options or lack of options for people in the United States. And we have not seen Congress pass a comprehensive immigration reform in as long as I just mentioned. Some recent examples of things that you've probably seen on the news are ICE raids everywhere, which includes people's places of work. We've seen them going to schools, to churches, courthouses, lots of family separation. There's been one law that Congress did pass, which was the Laken-Riley Act that we'll get into a little bit later, that really affects a significant amount of people. And another current case law that just came out a few weeks ago regarding the detention of individuals and whether or not they are eligible for bond. My work is very, very tough right now. And every single day, there's something new that's coming either through an executive order or through the Attorney General or through the Director of Department of Homeland Security. And honestly, it's tough to keep up with all of the changes and which clients it affects, because it's not just by country, but a lot of times it affects the person based on when they entered the United States, if they have convictions, do they have family members, and what they qualify for. So the changing daily landscape of immigration is definitely wearing some of my colleagues down on a daily basis in different immigration lawyer Facebook groups. We see people who are just at their wits' end because this is tough work. But like I said earlier, we are the people who are equipped. We have the tools, we have the knowledge, the training, and the experience to fight the injustices that we're seeing and to fight for our clients. And we're going to continue to do that. So the basics of immigration law. Let's talk a little bit about three different major things that I want you to understand and sit with for today. The first one is what I was saying earlier, complex system. Immigration is a moving labyrinth with many layers. In just the next slide, I'll show you all the different agencies that affect immigration. It's not just Homeland Security. There's more than that, but it's very complex. And most lawyers who practice immigration law dedicate their career and their practice to this particular area of law because there are so many changes and so many different agencies that are involved. We also have something that's called discretion, and it's exactly what it sounds like. ICE, which is part of Homeland Security, and immigration judges, they hold a significant amount of discretionary power. ICE in particular has the discretion to enforce or not enforce the immigration laws. And depending on the administration that's in power and control, as well as the Attorney General or the Director of Homeland Security and their desires, their agenda, that is what dictates the preferences. That's what dictates the authority and the discretion that ICE should or should not be exercising on any given day. Judges, to an extent, have discretionary power as well, even though they are bound by the Constitution of the United States and the immigration laws. There are many different forms of immigration relief that after you read all of the requirements, there's this last requirement called discretion, and it's up to the judge to decide if the person meets all the qualifications for the type of application that they've submitted. Does this person merit this grant? Does this person deserve the judge to approve their case? And then lastly, risk to all. Everyone is at risk right now. And when I say everyone, I mean every non-citizen. That includes people who have green cards, or also known as LPRs, lawful permanent residents, those who have DACA, TPS, and any other type of temporary protected status. For those of you who are in Georgia, I'm sure you saw throughout the month of May, the DACA recipient, I think she was from Cartersville or around that area, that was detained. She was invalid DACA status. She was wrongfully arrested by the local police, and then she was taken into ICE custody. And it took weeks in order to get a bond hearing with an immigration judge who agreed that she was not a flight risk and that she was not a danger to the society, and she was released on bond. In the past, we saw that DACA holders or DACA recipients were arrested, but not if they lacked zero criminal history, such as a young girl who was arrested out of Georgia. So when we say risk to all, we mean that many people in the past who are here with something temporary, or they overstayed their visa, or weren't at risk because prior administrations were more laxed with the laws and didn't enforce them as strictly as now, they are no longer safe. And with green card holders, we're also seeing that upon entry to the United States, they are scrutinized more than they were before. And Homeland Security officers are looking for anything in their past that is negative that could potentially affect their green cards now and place them in a deportation process. So immigration agencies, we'll go through this very quickly, but the major ones are in blue at the top. So we have the Department of Homeland Security, the Department of Justice, and the Department of State. And then to the right of that, unrelated to immigration, are just your local state courts. You have civil courts, criminal courts. Some of them are called family courts, some are juvenile courts, but those are courts that are controlled by the state and do not need to follow any of the federal immigration laws. Under Homeland Security, these are a few of the agencies. You have USCIS. That is the agency where everyone submits their applications for work permits, family members, naturalizations, green cards, U visas, T visas, DACA, etc. They are the agency responsible for processing applications that people submit to obtain legal status in the United States. You have ICE, which is basically Homeland Security police. Just like you have your local county police, Homeland Security as a federal agency has their police. We also have Customs Border Patrol. They are the people at the airport or along the border at different ports of entry that inspect every person who enters the United States and gives them the person permission to enter or not enter. And then lastly, we also have the Office of Chief Counsel, also known as the Office of the Principal Legal Advisor. Those are the attorneys that represent Homeland Security. So when someone is in a deportation process, it is the Homeland Security attorneys against the person who is in a deportation process. And then if you look over at the next bucket, the Department of Justice, that's where the immigration judges work out of. And the immigration court is also known as EOIR. Separate from that, we have the Department of State. That is the agency that is over all of the U.S. embassies and consulates around the world. They also follow the immigration laws, but they have their own manual and rules on how their officers are supposed to review cases. They are the ones that when someone goes in for a tourist visa or an employment visa interview or a green card interview at an embassy, that is the agency that controls. So if you saw recently in the news yesterday, there was a executive order banning a long list of countries from entering the United States. CBP, Customs Border Patrol, they are one of the agencies affected by this because they are the ones who approve or deny access. And then the Department of State is also affected by it because they cannot schedule any visa appointments for people from Venezuela, for example, nor can they approve any visas for people from those particular countries. So as you see, there are different agencies that are affected by this. Also, a few weeks ago, Marco Rubio announced that the Department of State has suspended the processing of all student and J-1 visas abroad for every single country everywhere. That falls under the Department of State. Let's talk a little bit about the basics of removal proceedings, also known as a deportation case. I explained that we have the Department of Homeland Security against the person who is in the United States without legal status or who has violated immigration laws. Those are our two parties. Then above that, we're supposed to have what's a neutral, unbiased immigration judge that is making a final decision on the case. Removal proceedings are very complex. They can take years. I've had cases that take more than 10 years through no fault of the client. It's simply that the court is rescheduling. They have a huge backlog of cases that they have been trying to process over the last few years. And some people currently don't have their first hearing until 2028, and we are now in 2025. The beginning of that process starts with Homeland Security filing what's called a notice to appear. This is the charging document that indicates you are a citizen, you're not a citizen of the United States, you're a citizen of Mexico, you entered the United States without inspection, and you're here illegally, basically is what a lot of notice to appear say. If there's something more complex, like a criminal conviction, which is probably what you guys will be exposed to, there'll also be a section on there that says, and you were convicted of XYZ crime on X date at X location, and you're removable from the United States. So once Homeland Security detains a person, they issue what's called a notice to appear. They file that with the immigration judge, and that's what starts the deportation case. Sounds a little bit similar to a criminal proceeding where a warrant is issued for someone that explains the alleged crime that they committed and then is filed with the criminal court. Removal is very similar. The biggest difference is that removal proceedings are civil in nature. They are not criminal. So the end result of a deportation case is not jail time or probation. It's your application is granted or it's denied. And if your application is granted, that means you get to stay in the United States. If it's denied, that means you need to leave the United States through a deportation and ICE will remove you. There are remedies after a case has been denied. The person can appeal. There's different levels of all the way up to the U.S. Supreme Court for appeals, but that is the very basic nature of immigration proceedings. And the one thing I forgot to mention is that once a person pleads to a notice to appear, then the judge will ask, okay, what do you plan to file in this case? What's your relief? AKA, what's your defense? And we'll get into that a little bit later in the presentation, but that is the very basics of how a deportation case works from start to end. If you encounter anyone that you're volunteering with and they have some paperwork, look for this notice to appear. It should have their name and some of the basic information that I just mentioned. And it's really important that you ask them, have you had an opportunity to talk to an immigration attorney? Some people will think that the notice to appear means that they already got deported or they have a deportation order, but it's the opposite. It's the beginning of the case. And every person in a deportation case has a right to counsel and seek an attorney who can help them. This is a little bit legal and technical, so we'll go through it very quickly on the next couple of slides. But basically, we have two categories when someone is in deportation proceedings. We have what's called inadmissibility and deportability. Inadmissible means you don't have any type of legal status and you're seeking admission, you're seeking perhaps a lawful permanent resident status into the United States. It sounds a little bit weird because you think that that only happens at the border or at a port of entry. However, whenever ICE encounters an individual in the United States without legal status and they start a deportation case against them, it's under the inadmissibility section of the immigration laws. Deportability means that you're already in the United States with some type of legal status at the moment, or you previously had legal status because Homeland Security approved you to legally enter the United States or to have legal status. Then the notice to appear will have a charge about deportability that indicates why you should be deported from the United States, and whatever status you previously had should be revoked. Either way, if you are speaking with your volunteer, with the prisoners that you meet, and you see on there either charge, it's still the same proceeding that I explained earlier. Lawful permanent residents, for example, who commit a crime that makes them ineligible to continue with their lawful permanent resident status, they're the ones that are deportable. Someone who entered through the border without a visa and has been here without legal status for 12 years, for example, like the one I mentioned earlier, that would be someone who's inadmissible to the United States. And there's different legal standards, but either way, for both cases, something that's significantly different in deportation cases compared to criminal is that we need to bring as much evidence as possible for everything that we are arguing against or that any benefit that we are applying for, because even though there is different burdens of proof, whether it's on the immigrant or on the government, anything we argue in court must be backed up by evidence. So if you're, working with someone who is defending their case in immigration court, or they're trying to do it on their own, their word alone and their testimony is not sufficient for an immigration judge to grant whatever application they are applying for. A couple of very common crimes that volunteers will see. Crimes involving moral turpitude. I'll talk about that in just a second. Aggravated felony, controlled substances, any type of drug or firearm offenses, domestic violence, stalking. We'll see in CIMTs, there's things like theft and anything that goes against societal values. As you've probably discussed, with some of the people that you support and visit, they might talk to you in terms of a misdemeanor or a felony. And something that's really interesting about immigration is that at a state level, something that is a misdemeanor may be interpreted by Homeland Security at the federal level as an aggravated felony. So people might think, oh, I'm just serving a sentence for a misdemeanor. I'm okay. I should be able to get out as soon as I'm done serving my time. Just because in the state of Georgia, for example, that particular crime is a misdemeanor, that doesn't mean that at the federal level for immigration, it's going to be treated as a misdemeanor. We'll cover that in just a moment. So crime involving moral turpitude, CIMT for short, versus aggravated felony. CIMTs are any type of offense that goes against societal values. So for example, things involving fraud, theft, or involving something that's dishonest, domestic violence can fall under there as well. And depending on the type of case, they may be eligible to submit an application and apply for something with an immigration judge, or they might need to request a waiver before they can request anything else. Aggravated felonies are generally felonies and things that are more severe, but it also includes some misdemeanors. Some examples, burglary, rape, anything that has to do with violence, even if it's a misdemeanor at the local level, depending on the terms of the sentence that the judge issues at the end of the criminal case, that may be considered an aggravated felony. Any crimes against children, crimes of violence, like I mentioned, controlled substances, depending on the type of controlled substance. Some are more severe than others, but they all fall under the same category. And one of the things that I've had to explain to families in the past, especially for controlled substance, is if the person had a small amount of a controlled substance or an entire trunk of their vehicle with a controlled substance, it is treated the same way. And so controlled substance violations are very serious under immigration law. All of these different crimes that are mentioning are some of the types of crimes that the people that you support may have pled guilty to or went to trial and a jury found them guilty. Or it's possible that they are not serving a sentence yet and they are awaiting trial and they're putting their defense together and they're represented by someone. If they're not represented, always encourage them to speak to an attorney and see what their options might be. This slide, very, very quickly, Padilla objections. There was a case in 2010 that came out of the Supreme Court that now requires criminal defense attorneys to advise their clients of immigration risks, because if they don't, it violates their Sixth Amendment. So many times, criminal defense attorneys will work out a deal with a prosecutor, and their experience is not immigration law. That's also not their area of expertise. They know how to get deals, how to avoid as much jail time as possible, and plead down to the least offense possible for their client. Well, there's always an immigration impact when someone pleads guilty to a crime, and this protects immigrants, this particular law, and their rights. So if you are with someone who's in the process of perhaps negotiating to get a deal, you should advise them, have you spoken to an immigration attorney? Has your criminal attorney spoken to an immigration attorney, to see how that is going to affect them? Also, when you're volunteering, you can ask, like, did your attorney tell you that this can affect your immigration status? I meet people all the time that get arrested for something and they're not able to get a bond, or their family's unable to pay for the bond that the local criminal judge issues them. And they'll sit there for months waiting for the criminal case to be adjudicated, to be reviewed by a judge, and to be decided. And they are desperate and they're no longer patient. And the prosecutors may say, hey, go ahead and take this deal. If you go plead guilty to this, I'm going to reduce it to this crime, and I'll also give you this little bit of jail time, or I'll give you credit for the time that you served. And out of desperation, people will go ahead and plead, and no one advised them of the immigration consequences. And so if you're talking to someone and they don't really, they tell you this story, like, I just couldn't wait anymore. I needed to get back to my family, my job, etc. So I just signed whatever they gave me. That is a case where they might have a claim under Padilla, and may be able to get their criminal case reopened. And if they get it reopened, they might be able to get a better outcome that won't affect their immigration case. So that's a little bit on Padilla, just to put a bug in your ear, that if you have someone telling you a very common story that I hear all the time, I just pled, I wanted to get it over with, ask, did anyone advise them how that could affect their immigration case? So ICE enforcement and detainers, we talked a little bit about notices to appear and how that's the document that starts an immigration process against someone who's here illegally or who has violated the immigration crimes. At the jail, before someone has pled guilty, they're not currently serving a sentence, they were just detained. Typically, in most jurisdictions, ICE has 48 hours to show up and take custody of the person. If the person's arrested, and let's say the local police say, oh, you can just pay this $1,000 bond, a lot of times the family is quick to go pay the bond, and then they find out, oh no, my family member has an ICE detainer. And ICE has 48 hours to go pick up. And for the most part, they show up on time. If they don't, then the detainee has the opportunity and the legal remedy to file what's called a habeas petition, which basically is fighting for the local sheriff or the local police department to release them because they no longer have a legal reason or authority to have the person in custody. Some local jails and prisons as well have a specific ICE officer or unit that is consistently there, and they work together. Under the current administration, there are many states who are now cooperating with ICE, which is something that we didn't see in the prior administration. And so there's a lot more access that ICE currently has to people who are in jail. Legal advice, if someone reaches out to you, what I just explained about the family paying the bond and then finding out that ICE has a hold on them, that's very common. On simple misdemeanors, as an attorney, once the family reaches out to me, I might advise them, yes, go ahead and pay the bond. But if it's something more complex that I know for a fact is going to affect my ability to advocate on behalf of this person and get a bond from an immigration judge, I may advise the family, don't pay the bond at the local jail. let's find a criminal defense attorney to represent your family member, because if they can get this case dismissed, or maybe they can get a deal with the prosecutor to reduce it to something that won't affect their immigration status in the future, that is a sacrifice that I believe is worth it, of this person sitting in jail and trying to get the criminal case resolved. If someone comes into ICE custody after paying the bond, and then I'm representing them with an immigration judge trying to get an immigration bond, and they have a charge that makes them look very bad to the immigration judge, the judge may decide, even though the client hasn't been found guilty by a criminal judge, the judge may say, I think they're a danger to the community, and not release them on bond. So it's really important that before families rush to pay a bond, that they consult not a criminal attorney, but an immigration attorney to determine, is it worth it to stay in criminal jail and fight it so that I have a better chance of getting out with an immigration bond later? Or do we just go ahead and pay the bond? Post-conviction relief, that's a legal term. The Padilla example that I just gave you is a form of post-conviction relief. And as always, advise them or recommend them to consult with an immigration attorney. Immigration relief after jail, after prison. The next two slides are something that I'm going to focus on, teaching you some things so that you can understand and ask some questions to the people that you support to help them understand that they might have an immigration option, and to maybe motivate them to seek counsel and to have a consultation with an immigration attorney who can review their case and determine if they qualify for something with an immigration judge. So we talked about how people are detained and a deportation case is started against them. We went through the criminal aspect of how that affects them being detained, or how it can affect their immigration case later, which is the part that we're getting to now. And what we haven't covered is who qualifies for what are kind of some preliminary questions that you can ask to help the person see that they might have an option. If you're volunteering with people who are serving a sentence, especially people who are serving a sentence for longer than 12 months, that means that they have been found guilty of a felony. Felonies are criminal charges, that are punishable by more than 12 months in jail. Misdemeanors, on the other hand, are criminal offenses where you can only be punished for a sentence of up to 12 months in prison, in jail. So if they've been in there for longer than a year, more than likely they have a felony conviction. Many people with felony convictions, the overall majority of them, do not qualify for immigration relief, but they might qualify for some special things. The people who have misdemeanor convictions, many of them may qualify for immigration relief, and it may be easier with a misdemeanor conviction rather than a felony to apply for something with the judge and possibly get approved. Some of the most common examples of things that we can file with an immigration judge are cancellation of removal for LPRs, lawful permanent residents who have a green card, and for people who are undocumented, immigration calls them non-LPR. They can apply for asylum. There's a variety of different waivers that are available to lawful permanent residents and some to non-lawful permanent residents as well. With USCIS, we can apply for a U visa, we can apply for a T visa, and sometimes we can apply for VAWA with USCIS, or we might do it with the immigration judge because there's an option with them as well. And there are also green card holders that are serving prison sentences that don't know that they're actually citizens because of special laws that may have, where they may have derived citizenship from their parents, or where they may have derived citizenship, again, from their parents, but after becoming a lawful permanent resident while they were under the age of 18. So when we meet a lawful permanent resident who's serving a prison sentence and is now going to have a deportation case, the first thing we ask is, was your mom or your dad a citizen? And if the answer is yes, then the next question is, did they become citizens before you turned 18 years old? And if there's any hesitation and they're like, I think so, or I'm not sure, We'll ask them to get in touch with their parents so we can see the naturalization certificate to see if it actually occurred before the person turned 18 years old. Because if they did and they had a green card at the time, they are US citizens. And all we need to do is apply for a certificate of citizenship or a US passport. And then when we get to the immigration judge, that is our defense. And the immigration judge will dismiss or terminate the deportation case. Those are rare, but I've seen them over the years, and I'm so excited when I find that out. But anytime you encounter a green card holder, you want to find out if their parents are citizens and if it occurred before they were 18 years old. And if their parents were citizens before they were ever born, then that's another example where the person might be a citizen. So let's talk a little bit about each type of relief that I just mentioned. But I want to go back again to the different agencies. So the Department of Justice is where the immigration judges work for the immigration court, and they have their list of applications that they can accept, that they have the legal authority to review the application, review the evidence, and give us the opportunity to present testimony, witnesses, and any evidence in the case. And then that judge decides, yes, I'm granting your application. You can stay in the United States and get a green card, or no, I'm denying your case. Separate from the immigration judge, USCIS, the agency under Homeland Security, they have the authority to process and approve applications for different immigration relief. And while someone is either serving a prison sentence in federal prison or they're now in ICE custody, USCIS has the legal authority to accept the application and process it. I always recommend that if someone is serving a sentence in a federal, is serving a sentence in prison and they qualify perhaps for a T visa because they were trafficked, then we should file it while they're serving their sentence and not wait until they get into ICE custody and in front of an immigration judge. So there's two different ways and legal authorities that can approve or deny certain situations. I'll go back a slide for just a moment. Cancellation of removal, for example, that's only immigration judges who have the authority to approve those. Asylum, for someone who is in a deportation case with a judge, only the judge can decide asylums. Different waivers can only be decided by the judge. U visas, because they've been a victim of a crime, a judge has no legal authority to approve or deny that. We need to file it with USCIS and wait for their decision. And that's the same with the T visa. VAWA, there's two different VAWAs. There's one VAWA that we can file for the client with USCIS, and then there's another one that we can file with the immigration judge. So again, two different ways to do it. The cases that can only be filed with an immigration judge, well, we can't file those applications until the person is now in ICE custody before an immigration judge doing their case. But all the ones over here that we can file with USCIS, we can file those ahead of time before they get to the judge and while they are with serving their federal prison. Oh, one more thing on cancellation or removal. For most people who are not current lawful permanent residents, that is for people who have been in the United States for at least a 10-year period, that they have been a person of good moral character during that time, and that they have spouse, parent, or children who are U.S. citizens or permanent residents that will suffer extreme and unusual hardship if the person is deported from the United States. For cancellation or removal, the good moral character requirement is usually the one where the criminal conviction disqualifies them. And most people that you may come in contact with who are not permanent residents probably don't qualify for cancellation or removal. If they want to apply for lawful permanent resident cancellation or removal because they have a green card, then it's on a case-by-case basis that each one of those has to get reviewed. I can't even start on how to help you identify those because we could be here all day. Those are very, very complex. Asylum is for people who have a fear of returning to their home country because they believe that they will be persecuted or have been persecuted in the past on account of their gender, political opinion, sexual orientation, or because they belong to a particular social group. Sexual orientation, gender, political reason, or religion, which I forgot to say, those are very clear, a little black and white. Particular social group is a developing and ever-changing area of immigration law. Particular social groups, some of them exist, and some of them, depending on the person who's applying for asylum, though their particular social group may not exist, and their application for asylum is the fight to establish that social group, and it may involve a denial and then appealing all the way up to the U.S. Supreme Court of that. But for particular social groups, some of them who have been established in the past, here are some examples. Indigenous women, in Guatemala who have suffered domestic violence through members of their family. There's also a particular social group for women from different African countries who have suffered female genital mutilation. There's also been in the past women from China who are required to have an abortion or have their children taken away from them upon birth. And there are so many, many more, but those are some really easy ones that may resonate with you that you can identify. Many people think that because of the gang violence or the narco violence in their home country, that they can apply and qualify for asylum because they have a fear of returning. And unfortunately, that is not sufficient under U.S. immigration law. You have to tie any type of persecution that happened to the person in the past or to a family member. That needs to be tied to the particular social group, the gender, sexual orientation, political opinion, or religion, and that they were targeted on account of one of those things. So a lot of times you'll encounter someone that says, well, my uncle was murdered and it was XYZ gang. Well, what we really need to show is that uncle was persecuted for a specific reason. Maybe it was on his political opinion. Maybe it's because he belonged to a gang and finally got out, and now this is a rival gang going after him. But just the fact that he was murdered, unfortunately, won't help someone win an asylum case, because people in the United States are murdered on a daily basis, and the judges don't consider that sufficient. So asylum is a very hard standard to show, and withholding of removal is for people who have criminal convictions that don't qualify them for asylum. They can perhaps get withholding of removal. If asylum is granted, you get a green card. If withholding of removal is granted, you don't get a green card. You are just allowed to remain in the United States and get a work permit indefinitely. Many people with criminal convictions may qualify for withholding of removal. And if they don't qualify for that, there's this other very rare option called a DCAT case. That's Convention Against Torture, and is very limited, but there are definitely options. So if you're speaking to someone and you think you're kind of connecting the dots on some of what I just said, encourage them to seek immigration counsel. Okay, let's talk a little bit more about survivors. And after this, we will be wrapping up and then opening it up for questions and answer. Some of the most common ones that we see are VAWA, U visas, and T visas. Let's talk a little bit about VAWAs. VAWA is a petition where someone who has suffered physical or emotional abuse by a spouse or a parent or a child over the age of 21, and any of those people I mentioned are U.S. citizens or permanent residents. For VAWA self-petitioners, we need to demonstrate to the government that the physical or the emotional harm has happened. We're seeing more and more that within the immigrant community, people are understanding that this is now an option if they have a kid over 21 who has threatened to call ICE on them, who has mistreated them. We've had cases in the past where the kid over 21 has a substance abuse addiction, and the immigrant parent has to pay and give them money to buy their substances. A lot of times also has them living in a separate apartment or location and is paying all of their bills. Sometimes they're also supporting the spouse and the children of their kid who's a substance abuser. A lot of times when the kid comes to ask for more money and the parent doesn't want to give it to them or doesn't have it, they will become physically violent. Physical violence is not required, but we've seen it a lot. And for spouses, we've also seen it as well, where they're controlling the immigrant's ability to work, their financials. Maybe the immigrant doesn't have any type of access to a bank account or where they can get access to their paycheck. Maybe the immigrant is not allowed to work because the spouse doesn't let them. They can't see their family. They can't hang out with friends. They threaten to call ICE against them. If they have children, they threaten to divorce them and take their kids away because they're the citizen and the immigrant doesn't have any legal status. So those are some of the ways without violence where we repeatedly see that people are victims of abuse. And we can apply either with the immigration judge or with Homeland Security. Good moral character comes in to play with VAWA as well. So depending on the sentence that the person you're supporting is serving, they may not be eligible for VAWA because they may not meet the good moral character standard. U visas. This is for people who have been victims of crimes and have cooperated with law enforcement. For example, the most common ones that we see are any type of physical violence, such as assault or armed robbery. Domestic violence is a big one. Any type of sexual assault against the individual or against their children, whether the child is or is not a U.S. citizen. U visas in particular have a special waiver that we're able to file. And in that waiver, we've been able to get some really serious criminal convictions, not overturned, but forgiven by Homeland Security. And it's always worth it to try and apply if the person qualifies. T visas. Oh, let me go back to U visas one moment. The biggest difference between a VAWA and a U visa, aside from all these extra types of crimes that I mentioned, is that the aggressor, the person who causes harm to the immigrant, their legal status is completely irrelevant. There's no need for a relationship or for the immigrant to know who's the person that caused them harm. For T visa, these are people who have been trafficked. And when we hear the word trafficking, it's like this big word where we think that perhaps someone was smuggled across the border on a truck, and that's trafficking. But trafficking comes in other forms. There is labor trafficking and there's sexual trafficking as well. I'll give you some examples of some recent cases that we've worked on, just so that you understand a little bit more about this. So we have someone we're representing that was an interpreter for a director of a nonprofit organization. And this person was only supposed to interpret on behalf of the Latino immigrant community. And this person was required to basically be available 24 hours a day, 7 days a week. This person would get called in to interpret and translate at any time of the day. Sometimes they would come in for an hour. Sometimes they would work 10, 12 or more hours nonstop without getting a break. They weren't paid adequately. Their scope of work went beyond interpreting. Whenever their boss needed anything, it's kind of like a personal assistant. The boss would call this person in the middle of the night to drive them here, pick this up there, do this, do that. This boss also threatened to call ICE against them and this person's parents. There were instances where this boss made the interpreter taxi the boss and a date somewhere, and the person was forced to watch sexual acts between the boss and this other person. And I can go on. There's just so much that happened on this case. That is labor exploitation, labor trafficking, 1000%. To an extent, also sexual trafficking, even though the employee was not involved in the sexual acts per se, they were required to stay there and watch what was happening. And so there's those two things that we were able to argue on that case. We have other cases where perhaps someone comes to the United States as an au pair, for example, to nanny for a family, and they're required to have sexual intercourse with one or both parents. They're required to do a lot of other things around the house. We saw a case where someone had to cut the grass with a scissor, which is not even part of the job that they were supposed to do. And it's also completely unreasonable and inhumane. They weren't allowed to leave the house. They were required to do chores and all day housekeeping in addition to the work that they were supposed to do for the children. So that's a sexual trafficking, and that's also a labor trafficking, human trafficking as well. And then for the people who come through the border with coyotes, there are situations where sometimes people are brought against their will, or they're required to help injured immigrants that they're trying to bring across the border, or they house them in a safe house somewhere close to the border, and they need to clean, or they need to cook, or they need to do different things. So that's a little bit more of example of human trafficking and labor trafficking as well. So ask some questions. I gave you some examples just so you have an idea of some of the things that you may encounter. Those last examples of what I provided are cases where even the most difficult and damaging criminal convictions are waived, and people have been able to obtain a T visa or a U visa, and after their prison sentence, rather than getting deported, are released and are able to remain in the United States legally. There's so much more I can say, but I need to wrap it up so that you guys have the opportunity to ask questions about this case. But just remember that there are resources. I'm a resource. There's also many different nonprofits. You can follow me on social media. I'm trying to, as much as possible, keep everyone updated on the immigration laws and the things that are changing. Immigration law is really complex. We barely scratched the surface today, but I hope that the information I was able to provide gives you some insight into some of the things that people who are serving sentences may qualify for, and your compassion, your curiosity, and your determination to help them and to bring support to them is really going to make a difference in their lives. Thank you so much for your service and what you're doing with the immigrant community that's serving their sentence. And I hope to do some additional training in the future, and that you found this valuable.
Thank you, Zaida. That was a lot of information. And now we would like to open the floor to Tonia Maglione to answer some questions. We already have some questions on the chat, but if you have additional questions, please feel free to enter them here. Tonia, we have a question. Do you know what are the laws or regulations about rights to visit a person in an ICE facility? Is there a special status for ministers willing to visit any person?
Yes, thank you, Imelda. Appreciate you give me the floor. Hello, everybody. Thank you for your questions. I'm going to try to be as much as concise and precise as possible. As Zara mentioned in the presentation, there's a lot going on under this administration, a lot of changes in also regulation and the way that also ICE facilities unfortunately regulate visitation, even if a ministry wishes to, of course, visit the detainee person. My first suggestion would be to reach out to the detention center. Most of these detention centers have official point of contact that you can find directly on the website of the detention center where your client is detained, and get in touch with the person allowed with visitation, taking consideration that each person, when he's detained, is assigned an immigration officer. Most of the time, to allow you a visitation, you do not need to reach to the immigration officer assigned to your client. You just need to reach out to the person in charge of the visitation program. There is a visitation program employee that is in charge of, again, put you in communication with your client. There is also to point out that most likely your status, it is a special status, right? Because you're a ministry, and most likely you want not just religiously or for case purposes support your client, at that point I would suggest also to file and send a letter from the organization that you're part of, showing that you are a ministry indeed. And I talk, for example, on my case, which I have a 3 detained client, unfortunately, currently. Before reaching out, I need to be ready by providing my ID, my bar number, and membership card, because they want to see my identification. So it will be the same in your case, of course, because they want to verify that your ministry, that you are a person associated with an organization. So my suggestion, get ready, gather your ID, your letter from your organization, and be ready to email them to the person in charge of the visitation program. If they allow you to go into the facility, consider that you have to be screened, right? There are some security steps, such as whatever you wear, you're going to be under the detector, and you will be scanned, and making sure that you do not bring any items that they're considered dangerous. Of course, you do not forget your ID and the purpose of your visitation. That will be specified when you will be in communication with the visitor employee. Let me share this about my own experience, that especially that I'm witnessing in the last few days. As a matter of fact, today, they are very, very kind. They're not associated with ICE officers, the person in charge of scheduling you, the visitors employee. They're not ICE officers, so they're very accommodating. Of course, each facility has their own regulations. Sometimes they can change, so do not be surprised that everything that I'm saying right now, it can be like twist around it, applying to another facility, detention facility. But usually they're very accommodating, and they want to support you. I hope this helped. I don't know if I was accommodating each one of the steps, but if you have any additional care, and if you have any additional question on that or concern, please just write it in the chat so I can address it for you.
And I wanted to say that we are a little bit short on time. We are on the hour of 2 p.m., but if everybody's okay, we're willing to go for a little bit longer so we can answer all your questions. But if you need to leave, please feel free to do so. Recording of this webinar will be available shortly on CPMC's website. We have another question, Tonya, and I think this is a question that is resonating with a lot of us. Should naturalized citizens be concerned with all the changes and all the policies? Should naturalized citizens be concerned about their safety,
Right. Let me start the answer to my question with the statement where naturalized U.S. citizens are entitled of the same rights as a United States citizen at birth, that acquired citizenship at birth. Okay, there's no distinction. The only thing that I want to point out is denaturalization. Okay, denaturalization is a very affecting consequences of, as the word say, denaturalized a person, meaning that the Department of Homeland Security can take off the status of denaturalization. Usually it's an immigration judge that take the final decision on that. Okay, it is very rare their naturalized U.S. citizen get to the stage of denaturalization. It could happen. If that happened, if one of your clients, one of the person that you're assisting is in the process or is accused by the department of being put in the process of denaturalization, it is because a specific fact that happened during the process while that person applied for the green card and then naturalized. I give you an example. Let's say that the application for the green card was based on a fraudulent application. where, for example, the person actually was not eligible for a green card. Let's say that also there was an illegal way that that person, when applied for the green card, went through the route of actually not being legal. So it was an illegal procured of their status. That can be under the radar of denaturalization. Have I seen these kind of cases, not specifically to naturalized US citizen, but to green card holders? Yes. Where, for example, I had potential client where, for example, they were inquiring about why they were being putting in removal proceeding, even though they were, green card holders, and at the border they were stopped and investigated by the CBP at the airport, put in secondary inspection, and then remember what Zara said, served with the notice to appear, which is the charging documents to initiate the removal proceeding. And I came to find out through an investigation with the FOIA, which is the Freedom of Information Act, which is another tool that you can use to screen these people that you're assisting, that there was a fraudulent path on how this person got a hold of the green card. So it is very case specific. You need to gather as many information as possible and really do a Freedom of Information Act. Not only one, there's several one. Freedom of Information Act can be at the border, which is called OBIM. There is also in a CBP that is focused primarily on what happened at the border when that person entered the United States. USCIS FOIA. There is a EOR FOIA, which is also only practicable with the court. So my main suggestion on that, yes, it could happen that a naturalized US citizen can be denaturalized, but needs to be screened very well and needs to be subject to investigation.
Thank you. We have another question. What are the steps that should be taken if you have a person who is incarcerated in a prison and you have been informed they will be deported when released? Is it common for ICE to be present at the gate when people are flagged to pick them up?
Yes. And they usually do not get deported immediately when they are released. The stages are this one. ICE, when a person is incarcerated, ICE get in touch with the local place, which is in this case will be the detention center where the person is incarcerated, and literally will say, please let me know, notify me on the phone whatever this person is done with the process, because we're going to put the so-called hold, ICE hold on him. What do you do? How do you know if that person has an ICE hold? You can call the detention center and request that information. They have to share with you, and they usually they share it. They share with family members. Sometimes a family member will call you and say, my husband, my wife, my family member has an ICE hold. They told me that has an ICE hold. I don't know what it is. What do I do, right? What does it mean that there's a ICE hold? It means that ICE knows that that person most likely entered and has inadmissibility, right? And entered, with, for example, without a visa, without being expected and or paroled in the United States. And because AKA does not have a legal status. And because of that, by committing a crime, they got into the ICE radar because they didn't know that, most likely, right? If they entered without being apprehended at the border, but because they were detained by local official and they were in touch with the database with ICE, that is when ICE is on the radar, and they will call and say, okay, I'm going to put a hold on him. As soon you release him, I'm gonna come to pick him up. What do you do in that case? There is a way to locate. You would know, of course, when that person it is on on the detention center, right? State or federal detention center. You will not know when and where is going to be moved by ICE upon apprehension, upon arrest. Not immediately. However, the person that gets arrested upon the hold and upon release to ICE can communicate with family member right away. They usually give the opportunity to communicate with the family member right away. And they will say, okay, they're telling me that they're moving me to this detention center. Of course, the information that most likely the now detainee is sharing with the family member, most likely they're not accurate. There is a way to accurately check if that person is detained, officially detained in a detention center, and it will show the address, the name of the detention center. And it is by going to the website, and it's called Locator, Detainee Locator, ICE Detainee Locator. I can share with you the link in the chat. You can go there, you put the A number, okay, because of your client would have an A number, which is unfortunately it's called alien, right? They call it alien. I prefer to call it immigrant, but it's an A number, it's an alien number. You put the alien number and country of origin, and you will be able to locate it. Once you're able to locate it, your client, that's when you gotta act very, very fast. You need to be involved with the family members because they're the one that can support you in, of course, gathering all the information, all the evidence in support for your client. Because at that point, and this can be a little bit prolonged as answers, bear with me. At that point, we need to identify if your client it is bond eligible or not bond eligible. If your client is not bond eligible, the only way to set him free is by discretion of the immigration officer that is assigned to him. An example when a detainee is not bond eligible, and unfortunately I have this case, is when the detainee has an order of removal. Okay, there is a matter, a law, a matter of MS that does not make that person unfortunately eligible for a bond. At that point, my suggestion is get in touch with immigration officer, which is not easy. I give an example in my case that I was working on before I met with you today. I had to guide the spouse of my client detained to go to the ICE office and get the information of the officer that is in charge of my client's name because they were not able to release an email address for me as an attorney to get in touch with the officer in charge of my client. I was able to communicate with my client because, as I mentioned before, right, the visitor program is very accommodating. They're very kind. They sent me with a phone call with my client. Sometimes it's also a video call. But I was trying to get a hold of the officer because he's the one that I have to try to convince and set my client free because unfortunately she's not eligible for bond, that I cannot fight her case before an immigration judge. So sometimes you got to be creative and very kind. Be in the perspective that you need the immigration officer approval. You need them to your side. You don't want to be aggressive. You do not want to have that, that feeling of, oh, this person actually incarcerated my client. I'm so angry. We are, all of us, right? We are frustrated what's going on. But remember and focus that your main goal is to serve this person, to support the person. And if there is a way, a consistent way of communication, although tiring, I've been on this case a week, mailing and calling the detention center every single day. Do it. Do it. There are some officers out there, they're really willing to support you. And they will do it if they can, especially if your case is a nice case is a case where perhaps there's not criminal records, or they're minors, right? Because in your case, of course, your clientele will have a criminal, but they're minors, and they're like criminal charges like 20 years ago, 10 years ago. That can be a persuasive argument, leveraging the positive aspect of your client case, that will lead the officer to decide positively on your case. One last thing that I want to mention is the relief in court. Let's say that your client is eligible for bond. There will be the path for a bond hearing, and at the same time, the immigration proceeding will initiate, is when we have to prove that, of course, they qualify for relief, like a convention against the torture, asylum, VAWA, or cancellation of removal for non-lawful permanent resident. As you can see, it can be a little bit complicated, but bottom line, remember to communicate and do not stop at the first "no, I can't." That's my main professional and personal suggestion on how to tackle communication with family members, with detention center, and also, and primarily, with ICE officers.
Thank you. And our final question is, do you have any suggestions for a religious sister who is in the country for over 20 years, working in the community and working on her citizenship? She is very afraid. She has a green card and was born in Africa and has no criminal record.
Thank you, Milda. Well, first of all, congratulations. You've been here 20 years. It's a long time, right? That is wonderful. I am myself an immigrant. I've been here in the United States for 9 years. I know how you feel. I know that it's very tough being away from home, right? And now United States is your home, it's your second home. It is comprehensive, and it is, of course, normal to be afraid under this administration. And again, as an immigrant, but also as an immigration attorney, I would say, unless there are some discrepancy on how you achieved the green card holder status, unless there is some caveat that I will not be aware of, do not be afraid, or embrace that feeling and move on and apply for naturalization. Trust a person, professional person, that can guide you through the process, right? And go for that. The reason why I'm saying this is because unless, again, we go back to the same question of before, unless a naturalized United States citizen is denaturalized, there's no difference between a United States that acquired the citizenship of birth with the one that acquired with naturalization process. Same rights, same way of proceeding their life. And here's the bottom line on this one. If you are a lawful permanent resident, and for some reason you are accused and charged, not anymore accused now, especially under the new matter, like Ray Riley, you can also be only charged with a crime. They can initiate removal proceeding. Citizenship, even under this administration, when you trust the person that guides you and process your case, it is the great way to assess your next step in your life and secure that status, not only legal status, but also mental health and tranquility that you need as an immigrant.
Thank you, Tonya. We have no more questions, but I want to thank you, Tonya and Zaira from the Solano Immigration Law Firm for your time today. We have a lot of information to process, but thank you, and I hope everybody got all the information they need and that this is helpful for your ministry. And I want to thank you, everyone, for your time, for your willingness and your service in this community. Thank you so much, and we'll see you next time.